Good afternoon, everybody. My name is Shimeon Pass. A biblical name, Shimon, Shimeon. Our company is called Focus Management, and we have been active in management consultation for more than 25 years, doing projects with about 140, 150 companies worldwide. Most of the companies are in Israel. And we have been doing projects in various areas: manufacturing, project management, service companies like banking, insurance, credit cards, healthcare, a large variety. And recently we were involved in a project in the judiciary system in Israel. We were invited by the president of the Supreme Court. He called us. How can we help the system? We are not judges. We are not even lawyers. But together with the judges, we learned the system. And eventually, we got very, very nice results, which I want to tell you about them. I would like to say a priori that what we describe actually is a case. Okay, a case from Israel. Whatever I will describe was perfectly good for Israel and not necessarily appropriate for implementation here in Lithuania, and it has to be considered and checked whatever is really appropriate for implementation here and whatnot. Our team is composed of 3 persons. The head of company is Professor Boaz Ronen from the Tel Aviv University, and we have a lady, Shani Karmi, and myself. I would like first to give you an idea what is the meaning of a law court, since I imagine that not too many of you are judges or even lawyers. Can you raise up your hands? Who of you is a judge or a lawyer? Nada, no, but you are half a lawyer? Okay, very well. In any case, I'll do it very slowly just to give everybody an idea what I'm talking about, because the terminology is maybe quite new to you. And I'm talking about a district court, okay? We have the Supreme Court, the district court, and underneath is the magistrate court. And we did projects with 3 district courts, 1 magistrate, and right now we are doing a project with a family court in Israel, which is a different story and even more complicated. But we hope we'll give them some good improvements and good tools to work with. In a typical district court, we have per year, per annum, we have 13,000 incoming cases. A lot of cases. And the working process, those cases that the judges started working on but didn't finish yet, amount to 15,000 cases. Okay? A lot of working process, or WIP as we call it. How is the system working? We have, in a typical case, we have 3 pre-trial meetings, and we have 7 evidence meetings. And I'll explain it to you in a minute. Just to give you an idea, there are really a great variety of cases. But as always, there is a majority of work, and there are a lot of other cases which are probably much rarer. And then is an important issue, mega cases. What are mega cases? Mega cases are cases where there might be about 80, 100, sometimes 200 meetings in a specific case. And why is it so? Because there might be many claims, a lot of witnesses, and so on. So it's a huge case, a huge trial. And interestingly, those mega cases, although there are only 20 per year per court, they actually they drain about 50% of the resources of the court. Why is it so? Because usually they are with a panel of judges, 3 judges, and as I told you, it's a lengthy process. Typically, we have 4 parties per case. In the mega cases, you might have lots of them. It's better for the parties to have a settlement at some case, and of course, it's better for the system where you don't consume their resources, or some things that you can get a settlement, an agreement among the parties. Okay, so there is a constant struggle, and I'll show you how it's working to get a settlement. And a settlement is not a compromise. He wants 6, he wants 2, it's 4 in the middle. No, usually it's a win-win settlement, win-win agreement. And the question is, if we have such a system, can we apply the usual approaches and tools? For instance, the TOCs that we heard all morning. And the answer is no. Probably we need something more than this. But we'll show you that the basis is actually the concepts of TOC, and then we add on top of it new ideas. Typically, the low-code system has low flexibilities because judicial processes, are very strict and cannot be changed without legislation or regulation. If you want to change something, it must go through quite a lengthy process of change. And contrary to, say, industry or the public service, judges are autonomous. He is a king in his court. Okay, you can't force him anything. And what we did during the implementation project, that we say, whoever wants to join the band, the wagon, you're welcome. If you don't want, we don't bother you. But eventually, nobody say, I don't want it. Eventually, everybody was on the wagon, and we are very happy with this. But we didn't force anybody. The judges, they are very professional, but very poor managers. And this has to be changed, and I am very glad that we succeeded in changing it. And to the degree that right now we have a course in the university, which is an open course, not for the usual students, which is called The Judge as the Manager. Okay, and the judges come and for about 10 meetings, half-a-day meetings, and they learn all these basics of management. What is quite unique about the judiciary system is that you have 50% of the participants working against the system. And let's think about healthcare systems that you'll be talking in the afternoon. What would happen if in the health system, when you are a patient, 50% of the parties will act against you. The nurse will give you the wrong remedy, and the doctor will cut the wrong hand, and so on and so forth. But this is what happens in the law court, that you have actually conflicting interests. So what we feel, and I think that you got the feelings that this kind of complexity actually deserves or demands a different approach. What we do, we were astonished when we made some survey in, as you say, overall it's 22 countries, and we have seen that it's not the problems of Israel only. The same problems everywhere. What are the problems? The demand for the intervention of the law courts is increasing with time. Life gets more complicated, and there is need for the intervention of the law court system. The costs are increasing. Very long lead times. Some cases, and not a little portion, but quite substantial portion, might be as long as 8 or 10 years, which is unbelievable. The throughput was quite low, and there was a high degree of dissatisfaction in the public. And we have to understand that if we delay the justice for 8 years or 10 years, then actually it's like doing no justice, justice denied. Okay? Because it's too late. Maybe some of the parties passed away and so on. Their business is suffering. So it's not good. It's something that you can't agree to it. So we thought maybe we'll find a rigorous solution, but we didn't find one. Okay, it's just a joke. I'll go and tell you the results in advance. What we have done, what we have achieved with those 4 law courts that I told you, the law court in Tel Aviv, in Jerusalem, in Haifa, and the magistrate court of Jerusalem. They're not the same size. The Tel Aviv district court is twice as much as the second one. And this makes sense because Tel Aviv is, the business center of Israel. But in all these cases, we got a reduction of lead time by 47%. The throughput, which is saying the same thing, the throughput was increased by 43%. And what is amazing that we didn't compromise the quality of the process. On the contrary, we improved it. And you can see it again and again in all kinds of areas. Doing things promptly doesn't mean that you just do it very in a sloppy way. On the contrary, your process is much better and the quality is improved. And of course, the satisfaction of the public is improved dramatically. Let's have a look at the process. Okay, the cases are incoming. Whoever gets them is called the registrar, and he goes through the material he gets. Something is missing. He tells the parties, and once he have all the information and will talk about this issue, then he actually can deliver it to a judge. Okay, and pre-trial is already the start of the judge's work. Okay, we have pre-trial, and then we have the evidence sessions, the summation by the various parties, and eventually we have the ruling by the judge. Okay? If the process goes all the way, there is a ruling by the judge. Okay? A very, with all the explanations, all the arguments, and so on. And as we described previously, we want that maybe in this case, we have some kind of a settlement. And to give you an idea, from all these cases coming into the funnel here, only 40% get into the evidence phase, which is quite nice. 60% are some way resolved by a settlement. Okay, is this point clear? Okay, quite a high degree of a settlement, and it's actually an activity that the judge has to be involved in it very, very actively. So let's call this 2 stages the pre-trial. This is the evidence, and this is also a very important stage. It's part of the pre-trial, but this is a very, I would say, very structured meeting that we make sure that everybody is okay and we are able to go into the evidence phase. And we'll have a look at it further on. So the overall challenges that we had is to increase the throughput and with it together to shorten the lead time, to reduce the complexity of management, the low code, and improve public trust, which was at the beginning very low, and somehow reduce the cost of doing business in Israel. Because if the low code system is not working properly, it means that there is a burden of substantial cost on the businesses that have to be actually come to the low codes. And in real life, in a modern economy, quite a substantial part of businesses have to arrive to the low code in this way or another. So let's go via the route of the TOC, and probably you have seen a lot of it today. We have seven steps. System goal. In a business organization, the system is quite, the goal of the system is quite obvious. We want to increase the value of the company, to make it, to earn more money and make it more valuable to the stakeholders. But here we have another goal. The goal is to provide ruling, not compromise. There's no ruling. Actually, the judges has to come to arrive to a decision. Even these settlements are actually followed or backed up with a decision. When they say, the parties say, I agree, I can't, so it's written by the judge, this is a decision, and it was arrived by consensus by all the parties. And also important to understand, actually, the global sense of making justice. If you're not aware of it, then you say, I right now have to invest as much time as is needed for this specific case. But it's wrong, because if you invest too much time in a specific case, there are 10 or 100 waiting for you outside, then you make no justice for them. So we have to find the compromise. I mean, as a manager, here comes the managerial aspect of being a judge. You can't say, aha, I'm only on this case. No, you have to actually to bring justice to the society, to the public as a whole, in the global view. Is it clear at this point? You should find the right way how to make reasonable justice to the specific case, but remember that there are other ones waiting for you outside. Step number 2 is to decide if our goal is to give those rulings, how can we measure ourselves? And here we suggest what we call measurement profile, a whole profile of aspects of your performance as a system. It's the throughput, how many cases, it's your cost inventory, how many cases are waiting for you to finish them, the lead time, which is highly important, the quality, and your due date performance. And this is something that we are in the middle of implementing. And what is mean a due date performance? That we actually want each stage of the trial to have a due date. For the first step, you can have as long as 4 months. The pre-trial, since you have to look for information for the parties, where is living, the one your defendant, you don't know the address and so on, it takes more time. Right now we decided it's 16 months. The evidence no more than 8 months. And then the ruling and the verdict, written verdict, 2 months. Okay, so it's a very specific plan. So this is the shortest that we decided that right now we can, to take some responsibility of it, and we give feedback to the judges. How well do they stand to these norms? It's not mandatory, but from day one, all the parties, all the lawyers know that this is the plan, and we want, as much as we can, to be inside these limits, this plan of due dates. Okay, and this is how well we do in this respect. This is a measurement of due date performance. Step number 6, identify the constraints. What actually stops us from completing more cases? So you don't have to be a genius to understand that the bottleneck of the system are the judges. Okay? And more than this, probably one can call them permanent judges. Even if you add more and more resources, more judges, without changing your managerial processes, there will still be bottlenecks. You add 5 more, 5 new bottlenecks. Welcome to the club. You add 10 more, still there are bottlenecks, and the system is not relieved by adding resources. And our project was about how to get more throughput with the existing resources. And it can be done. And if you think that it comes with more load or effort on the judges, and here again, on the contrary, less load, less effort. When we started, the judges were working in the offices, in the halls, in the personal courts until 6 o'clock. But that's not the end. They were going home, and everybody was hooked to the system, to the computer from home, with a card, you know, a special card, and they were working typically 10 o'clock, 11 o'clock p.m., I'm talking, okay? So the situation wasn't good. And everybody was waiting for some relief. Step number 4. This is your force of judges. As I told you, about 50 judges. In the case of Tel Aviv, we have more than 60, 65 judges. How do we exploit them better? And there are two aspects, and let us start with a simpler one, which is here. Reduction of the ineffective time, and sometimes we are blunt, and we say this is the garbage time. Inefficient time, it's very polite. Garbage time, you have to say it in order that everyone should understand that you have to fight it. And everywhere, not only in the law court system, everywhere this garbage time is enormous, is at least 50%. At least 50% everywhere. People are wasting their time on some things that don't have to touch it even, okay? What is ineffective time? It might be, for instance, there are false claims. Somebody gives a claim to the case, and it's nonsense. Okay, he's wasting the time of the judges. Everybody is preparing for a session tomorrow, and we got a phone call from some lawyer, from this side or from the other one. Sorry, I can't do it. Let's postpone. This is called contingencies. Sorry, continuations. Sorry, can't do it. Let's postpone it, and so on. Another source of this garbage time is the fact that we have a session right now, okay? It's 4 o'clock, so we fix a date for the next session. It might be in a year's time, or perhaps 10 months, 6 months. This is the norm, okay? The next available time for the judge, he opens the diary. Now it's in the computer, and we throws it. And what is the meaning of throwing the case for such a long time? That whenever the next session is coming nearer to, he has to invest the time to go through the whole file, all the steps, and he doesn't remember what happened. Can he believe? Does he have any confidence in this witness, in his evidence, or not? So it actually undermines the quality of the system, and it causes a lot of garbage time. Another source is the issue of the complete kit. Before we started, it was very often that the judge got the material from the registrar. They are sitting in the first session. Something is missing. No, sorry, we can't go any further because this is missing. So let's meet in another time. Waste of time. Waste of time even going to the evidences. If we didn't finish these pre-trial activities, then it's a waste of time to spend a whole day of hearing the evidences if something is wrong. If we didn't sit with all the parties to understand what are the disputes, okay? Where there is some disagreement between the parties, and where there is not. If the boss agree on some point, let's put it aside. We don't have to discuss it in the evidence phase, and so on and so forth. So you have, whenever you have a session or any other activities, writing your verdict and so on, be sure that you have in front of you the full kit that is necessary in order to complete it in one go. Okay, this is the meaning of a complete kit. Whenever you start a job, make sure that you have all whatever is needed in order to finish it one shot. Okay, this is a complete kit. So I think this very important issue of garbage time or garbage plant, we call it, because we are producing here a lot of garbage. I hope that this is clear to you. Is it? The issue of what is a garbage time, garbage plant? And believe me, it's amazing how much garbage. You know, developers, let's take developers of IT. There are organizations that depend on it. For instance, telecom, insurance, banking, and so on. All their businesses is dependent, nowadays are dependent on information systems, and they have also their permanent bottlenecks, the developers. And although they are shrewd people, very talented, and although their activity is very important, yet you have this magic number, 50% of their time is wasted. And most of it of working with an incomplete kit. Not everything, not all the requirements, the needs of the customer are there. You're laughing, you know, because of what I'm talking or something else. Okay, so, so I thought that you actually say we have the same problem in our place. Okay, so let's leave it aside, this issue of garbage plan, and let's go to another issue of the strategic gating. It's also very important in all the systems. Let's a priori have a look and decide what we will do and what we will not do. Since we are bottlenecks, I'm as a judge, I'm a bottleneck, I cannot do everything that is expected of me. So let's be smart and decide this and this and this and this and this I'm not going to do. And I'll put my effort on those activities that bring most value to the public. Because you remember, this is our mission, to bring justice to the public, to bring ruling as much as we can. How is it achieved? We try a priori to do an alternative dispute resolutions. It's called bridging, okay? Mediation, you know what I mean by this? Okay, when the parties sit aside and try to get in agreement to find a solution. And there are types of cases that it's mandatory. Before we start with a pre-trial sessions, we give a try to succeed with this ADRs, alternative dispute resolution. False claim, I told you some of the cases are bullshit, you know, and it's a waste of time. So there is somebody in the law court, like a president or a vice president going through the cases, say, this is nothing, let's throw it aside. It's a false claim, let's not invest any extra minute on it. And this also the strive of settlement, because before we invest this effort of going through the evidence stage, let's say if we can reach an agreed upon settlement between the parties. Step number 5. We know that we have a bottleneck, the judges. We know we have already a plan how to actually to get as much as possible from this bottleneck, the judges. Then we have to look a little bit in a broader look, the rest of the system, subordinate the rest of the system to the constraint. Let's see how the rest of the functions, the rest of the players in the law court system can help the judges do whatever they need to do. And it starts with the lawyer. They have to understand that they can't play with the judge. The hours or work hours of the judge are very precious. They can't play around. And for instance, in this issue of continuation, that was what really a plague, a disease. Everybody was saying, let's postpone it and so on. And throughout this effort, this project of ours, we convinced the system that it's unacceptable. And there came a policy up from the president of the law court system saying, no more continuation, no more postponing the meetings, the sessions. If you want, you have to convince us that it's a really good cause that you have. For instance, some of your very family passed away. It's a reasonable reason for postponing. Otherwise, maybe you'll send some other lawyer from your office. If you are, I don't know, abroad, or you are in a military service and so on. Otherwise, we don't postpone it. Even the experts can't. We need to change batteries? You think so? Even the experts, sometimes we have to get the opinion of experts like doctors of various kinds. Well, what is the estimate of the sum of amounts that the insurance company has to pay to those were injured in, say, a road car accident. So there was a tendency, I'm not free, I can come. The experts were also playing. No more. If you say, I can't, in 8 weeks, in 10 weeks, then you are crossed from the list of the potential experts. If we see that you are playing with us, the judge is number one. Everybody has to be subordinated to him. So is the administration, the witnesses, and so on and so forth. Got the point. Thank you. Let's have an idea how is the system working. 100% arrive at the pre-trial phase. As I told you, only 40 go further because there are settlements on the way. Each session of the pre-trial is about an hour. And nowadays what we do is that the judges start their day with 2 hours of pre-trials sessions. And after this is devoted to the evidences. Evidences, since they are a day, for a day, or half a day, and in a total it's 4 days on the average. I told you this mandatory pre-trial session, which finishes and makes sure that we have the complete kit, is very important. And actually, it's very nice because the judge got a good idea what is going on. He said, I don't have to listen to this and these witnesses because there are other ones. Maybe they'll tell us the same story. So he has a more concise list of witnesses, and he plans the time. This witness, I will hear it for 1.5 hours. This one, it will be half an hour, and so on. Everything becomes much more structured, and even the summation are going to be changed. Traditionally, the summations were prepared in writing by the parties. Each party was preparing, a very large document with all the stories and so on. To be on the safe side, they wanted to write everything down. So it puts a burden on the judge. He has to go through this all huge document, and sometimes he has some more questions, and the document can't answer him, so he calls them once again. So it's a pity. What we are doing, and it was very quickly adopted by all the systems, that we, instead of having a written document, we have an oral summation. The lawyers speak and give the main points, and if there is some points that the judge is not satisfied, he asks for more, deliberation in this point or another, and it goes very fast. You don't waste time on this issue of the summation, which was really a burden previously. So this is a time frame. I told you 2 hours in the morning, and this for the rest of the day. And actually, for the judge has a lot of time, for pre-trials. The main issue remains this evidence phase. And let's see how we improved this side of the equation. I want to give you some idea about the issue of work in process. As I told you, the process in the law court was this way. I hinted to it. Let's say we passed through the comprehensive pretrial session, the summary, and the judge opens his diary 6 months from now, 8 months from now, and so on, and the 8 months already arrived. We have the session. Once again, he opens the diary. Once again, 6 months or 8 months or 10 months, and so on, and everything is so it takes so much time. But what is the meaning actually that the cases take so much time? In a specific point in time, if you ask the judge in how many cases is he involved? And previously the answer would be 60 cases. He's in the middle of 60 cases, juggling. Do you work on 60 issues at one time? It's really bad, because he loses the contact with the case. And we actually succeeded in doing that by having a weekly hearing, and I'll tell you how it's done. The practical week per judge is no more than 5 cases. So he's very proficient in what is happening. He's in business, he knows exactly what is, and he remembers everything, who said so, and can he rely on it, and so. So it's really, in a way, it's a revolution. So let's give you an idea. This is actually a scheme of this long list of cases that are in the whip, okay, in the process. This is the case number 1. He finished it today, and when is it, planned for the next session? Over here. Okay, this was the routine. So maybe instead of this, let's do a day-to-day hearing, A, and when we finish, we go B, 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 B. It's a nice idea, but some problems with it, because lawyers don't like it. they have to devote themselves only to one case, and usually they have more clients than one. So what we found is a good compromise, managerial compromise, not in terms of justice, that having a session each week. Let's say we finish the pretrial, the judge opens the diary. When do I have the first opening in my diary? 6 months from now. Okay? 6 months from now. So he said to the parties, write down in your diaries, first meeting is 6 months from now. Second one, 6 months plus 1 week. The other one, 6 months plus 2 weeks, plus 4 weeks, plus 5, and hopefully we'll end it. Okay, so everything is actually, is it clear? Or once again, 6 months is the first session, because this was the first opening, and then a week after that, 2 weeks after that, and so on. So this is actually the new regime. Let's keep about this consideration. And we have actually a conflict that I told you about. Maybe day-to-day is better than a weekly hearing, but we say there is no conflict. There are some cases that day-to-day hearing are necessary. In other cases, we don't want to quarrel with the lawyers. And in the cases that it's necessary is a mega files. These are those huge cases with 80 or 100 sessions. So in this case, we go one by one, day by day, and the lawyer, either a single lawyer or panel of lawyers, are totally devoted to this. Otherwise, we are going to the weekly hearing. And we have, similar to the healthcare system, we have also a warning system. Okay, and this is the president of the law court, maybe the vice president. He checks where is the first opening of a specific judge. Is it the first opening is 6 months from now? It's okay, no problems. The next time you might get a file, a new file. If the next opening is more than that, about a year from now, it's not so good. We start to worry. But if it's more than 12 months, it's unacceptable. And the judges actually, when we are here in the yellow zone, we stop distributing files to this judge. We don't want to burden him with extra WIP, extra inventory, which will aggravate the situation. We just close the gate and we give it to other judges. Okay? An important improvement that we have introduced with them together, to have the judges have a legal aid. And nowadays, everyone has a legal aid, at least one. It was funny, in the beginning, scarcely the judges didn't like the idea. I don't know how to make use of the legal aid. And now everybody's saying it's a blessing. It's a blessing. And it was funny that we even help the judges understand how they can make a good use of this legal aids. We were sitting with them, you can give them this activity and this activity. Today, the legal aids are going to have the information and all the precedences and so on from other cases. They prepare the draft of the verdicts. They write down in the interim They write down all the aspects or consideration, what are the disputes and so on. They are working in the back office, and they are a great relief for the judge. For instance, we have the issue of request. Why should the judge deal with the request? He wants now to add another document, so on, so on. He can do it. The legal aids. He can, if there is really a need to do a continuation, a postponement of a session, that's he's part of his job now. And it's really, they're actually doing about 30% of what was traditionally the job of the judge. And I was talking about this permanent bottleneck. The judge is a permanent bottleneck. So, what did we achieve? Actually, we in the pre-trial ruling, from pre-trial, the final session, to the ruling, the lead time was cut by half, and the life cycle, total life cycle, which a large part of it is not dependent on the judge, was cut by 27%. What was the throughput? And here is just an example from the magistrate court. We have 25%, 28% more finished files. So cynical persons would say, probably you added judges. No, we succeeded doing it even with less judges, with 17% less judges than previously. How did we do the implementation? The chief justice, the president of Supreme Court, was a key player. And there were 3 of them giving, all the backing and the pushing. We gave 6-day seminars to president, vice president, and for each court, everybody was trained, legal aides were trained, even secretaries of the judges were trained. And we gave them, all the help that was needed. More or less, I covered these topics, how we did the practical implementation, what we were skeptical at first, but amazingly, we got all the cooperation of the lawyers. From the start, we were sitting with them, and they are explaining what are the steps that are going to take place, and nobody say no. Sometimes they said, what took you so long? Okay? Because it's eventually for their good as well. And the implementation was not, out of the box, and we customize it per court, because in different law courts we have sometimes other culture and other needs and so on, and the issue of measurement and control. And today everybody is really happy, and we are going further to implement it. What are the next steps? I told you that we are in the middle of the situation of having those due dates as a plan for the cases with measurement. And this is something also quite unique, that we are trying to implement the project management aspects to those mega files and consider them as a project. Yeah? Okay, which is quite new. Okay, do you have any questions, short ones perhaps? I'll be glad to, yeah.
If you plan 6 months from now, 5 sessions for each Monday, what happens with the 3rd or 4th Monday? What happens with the 3rd or 4th Monday when it is not needed?
It was covered in one slide that I skipped over it, but I'll tell you. Okay, it's it's not a disaster because the judge actually has what to do. He has to devote time to writing. So if it happens that he finished earlier, then he have more time to writing. And if we are talking with this issue, another revolution was the fact that from five working days, 1 day for each judge is now devoted to writing. Because the judges were, you know, it's a difficult, a demanding task to write the verdict. So they were, you know, postponing it, not now, not now, not now. Now they have a full day each week for writing, and the lead time, the average lead time is much shorter, and especially since the system expects them to have a shorter document. For instance, as part of this endeavor, the administration of the law court in Israel has a training unit, and they nowadays offer a course for all the judges of concise and effective judiciary, legal writing, how to write the documents, the verdict, effectively and much shorter, to the relief of everybody. And it's nice, one of very prominent vice presidents in one court told us after several months, you know, I was the first person that was looking for the perfect verdict with covering all aspects. And nowadays, I understand that I was totally wrong. So it's really, and now I'm looking for the shortest possible verdict, to the point. So if he said so, and really, now he was actually moved to the Supreme Court of Israel, since he's a very good judge. So it told us I was totally wrong. It's unnecessary to write those PhD dissertation. This is enough. Any more questions? Thank you very much.